Hi, I am Joe Maskovyak, and I am an attorney with the Ohio Poverty Law Center. We are here today to talk about foreclosure and manufactured housing.
Is foreclosure a typical remedy in manufactured housing?
No, but it's probably more common in rural areas than in urban suburban areas. This is because a manufactured home or mobile home by itself is not considered to be real property like a typical home that is attached to the land on which it is built. A mobile or manufactured home has a title like a motor vehicle. A manufactured home is considered to be mobile, even if, as a practical matter, it is not, and separable from the land on which it rests. This is most obvious in a mobile home park, where there are many residents who own their home but rent the land on which it sits.
Does this mean that if a lender of a mobile home wishes to take back the home from the owner because the owner is in default on payments, the lender does not need to file a foreclosure action?
That is correct. In Ohio, far more often than not, a mobile home is considered personal property, not real property. A lender must file a foreclosure action only when a loan involves real property. When you buy a typical home, you are buying the structure, the house, as well as the land. Most transactions involving mobile homes do not involve real property. When one borrows money to purchase a mobile home and takes out a loan, it is more like a car loan where the seller, or the finance company if different, physically holds the title as collateral for the loan and then transfers title to the buyer when the loan is paid in full.
So when is it necessary for a lender to foreclose when financing the purchase of a mobile home?
When a purchaser seeks a loan that combines both the mobile home and the property on which it sits as one loan, as one transaction, the lender and purchaser will need to use a mortgage to secure both the land and the home as collateral for the contract. Although a foreclosure action may give a borrower better legal avenues to defend against the lender, the risk is also multiplied because the borrower will lose both the land and the mobile home if they lose in court.
Let's say the mobile home is not tied to the land. It is in a manufactured home park. What remedies does a seller-lender have if a buyer-owner defaults?
Well, there are basically two remedies a lender may use. First is repossession. This is no different than a lender on an auto loan repossessing a car when the buyer is in default. The lender literally has someone go out and physically repossess the home, just like the auto lender gets someone to hijack the car. Of course, this must be done when the owner is not present to defend the property, since such a repossession may only be legally accomplished when there is no breach of the peace. In other words, the owner is not present to defend the property from the repo man. This obviously is much easier to accomplish when finding a car without the owner in it than an unoccupied home. In addition, if the home is located on private land, any unauthorized entry onto the homeowner's land would be considered trespassing.
But you said the lender-seller has another remedy in addition to repossession.
Yes, it is called replevin. By filing a replevin action, the lender is asking the court for permission to seize the home on very short notice. The court then sets a hearing, which is usually held within 5 to 10 days, so there is little time to prepare a defense, much less obtain legal counsel on such short notice. At that hearing, the court will determine which party has the right to possess the mobile home while the court case proceeds. The homeowner will often have to post bond as a result of this hearing if they want to stay in their home during the court case, unless the owner can show the court that the lender failed to follow proper procedure. This can be very difficult to do without the assistance of a lawyer. Contrast this with a conventional foreclosure action, which has many steps and can take months to conclude. In addition, the homeowner continues to live in their home during the course of the foreclosure action. Many owners will not be able to post bond in a replevin hearing. If they could, they probably would not be behind in their payments. Consequently, often what occurs is that the buyer is put out of the home and thrust into the position of trying to get it back. It is often difficult to find a defense that allows the owner to reclaim their home, not to mention the difficulty of trying to fight a court battle while avoiding homelessness. As I mentioned before, I think it is critical to get a lawyer in these kinds of cases. So I highly recommend that any mobile homeowner who finds themselves named in a replevin action find an attorney to assist them.